Prelims or like generally?
In general.
In general?
Yes.
Yes.
Okay, I was told this was supposed to be a prelim specific class. But okay, fine. Anyway. Alright, I hope all of you have your bare acts in hand.
Yes.
And as far as I was told, this was supposed to be a prelims oriented class. So I'm going to keep it to that. Have you had any classes on evidence before this? Not a single class. Okay. Okay, anyway, since prelims will be the first stage, let's try to first cover the bare provisions. Alright, then we'll again come back to the same provisions in a little bit amount of detail. Alright, so the method that I'm going to try to teach you over here applies for both prelims and mains, because if you know, procedural law is such a paper in which you do not have to refer to cases anywhere. Right, except for maybe if you have a question on, let's say, bail, right, in which you might have to refer to 2 or 3 cases. All the other questions you can take care of without referring to any case at all. If at all you will get a question, it will either be based on the principle itself or it might be a problem based question, right? Now, having said that, when you're looking at any enactment, studying any enactment from a prelims point of view, it's important to note that every single aspect of the act is not important, because not everything is going to come in the exam, right? But certain things that will always be important will be, for instance, the number of the act, right? So you can open the bare acts. Indian Evidence Act, just underline, it's mentioned over there, Act 1 of 1872. Now you will probably also get a question, when was the act enacted? Okay. Now you might either be asked when was it enacted or when it came into force. Both of these are very different questions if you notice, right? Why? Because the date of enactment is when the particular bill became an act.
Yes.
Okay, but date of operation is when that particular act itself became operative as a law. Clear? So the date of enactment, just look at the bare act carefully and tell me what is the date of enactment of the Evidence Act. 1st September 1872. Is that the correct answer?
Yes, sir.
1st September 1872 is the date it... Exactly. It came into force. Okay? Came into force. The date is 1st September 1872. Enacted 15th March 1872. Now just also remember that even the Indian Contract Act came into force on the same date. Okay? Alright, now short title, extent and commencement. This act may be called the Indian Evidence Act. It extends to the whole of India and applies to all judicial proceedings in or before any court. Just underline the parts, judicial proceedings. Then including courts martial. Courts martial means any proceeding before a military court, except courts martial under the Army Act, Naval Discipline Act, Indian Navy Discipline Act or Air Force Act. So basically most of the military laws have been excluded in a way, but there are other acts such as Indian Marine Act and all of that to which it applies. But in terms of your prelims, again, it's highly unlikely that you will be asked a question from this. So just know that the application is to judicial proceedings in or before any court, number 1. Number 2, courts martial. But the ending part of this provision is important, but not to affidavits presented in any court. Does not apply to affidavits. Can you tell me why? Why does this law not apply to affidavits? What is an affidavit? An affidavit is nothing else but an affirmation of facts that you are making based on your personal knowledge and belief, right? That means that whatever you are mentioning in an affidavit can be manipulated according to your own wish, right? So if it were to be given the position of evidence, then what is the whole point of an inquiry anymore? Isn't it? Having said that, although over here it is mentioned that affidavits are not included in evidence, if the court allows the presentation of affidavits, okay, under which provision? Under which provision can affidavits be allowed? In CPC?
Sir,
Order 18 read with Order 19. Remember that. Order 19 defines affidavits. Order 18 talks about presentation of affidavits during the proceedings. Okay? So, does not apply to affidavits. But, in case of Order 18 read with 19 of CPC, as well as, you can check this, I think it should be section 295 to 297 of CRPC. Affidavits can be given. But remember, it's only based on the permission of the court. And nor to proceedings before an arbitrator. Does not apply to affidavits. Does not apply to affidavits, and also does not apply to arbitration proceedings. Why does it not apply to arbitration proceedings? What is the point of arbitration? It is to ensure that there is a fast procedure, right? If we were to introduce the Technical Rules of Evidence Act into the system, that will make the process slow, isn't it? And thereby it would defeat the whole objective of arbitration. For that reason, the Act does not apply to arbitration proceedings. Okay. So from this first section, all you have to remember is it applies to the whole of India, right? It also applies, over there you can see the words except the state of Jammu and Kashmir. If you have the latest Act, the words except the state of Jammu and Kashmir has been omitted by Act 34 of 2019. Please underline that, Act 34 of 2019. That's nothing else but your Jammu and Kashmir Reorganization Act. But it's important to know these Act numbers. Act 34 of 2019 applies to all judicial proceedings and courts martial. The courts martial that are excluded, you don't have to remember, you'll automatically recall it if you are faced with a question. And it does not apply to affidavits or arbitration proceedings. Came into force on 1st September 1872. So when you are revising the bare Act, don't read the whole provision. Just pay notice to the underlined parts. That's all. Now, second section is not important. Third section, or the definition clause. In this Act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. Okay, now let's try to understand each of these terms. And remember, when it says that the following words and expressions are used in the following senses, that means that the definitions that are given under there are only applicable to the Act itself. Right? These definitions are not applicable generally or beyond the Act. Remember that. That's why it's mentioned in this Act. These words are used in these senses. Again, you will see, unless a contrary intention appears from the context. Now, this is not essential because, first of all, rarely has this provision been interpreted, right? But the whole point of mentioning this clause is, if in a particular situation the definition does not perfectly fit, then in that situation some relaxations may be made. That's all that you have to know with this. Okay, first definition. Quote includes, this is how you should make your notes if at all you're doing that. Quote includes judges, magistrates, all persons legally authorized to take evidence. Okay? Now over here it's mentioned except arbitrators. Now can you tell me why over here it's mentioned judges and magistrates? They could have very well mentioned only judges. Why did they mention judges and magistrates?
So because they both hold different powers,
Very good, because we are using the word judges in the sense of civil law and magistrates in the sense of criminal law. Okay? And then all persons legally authorized to take evidence. Tribunal judges, right? They are included under this definition. But again, arbitrators are also legally authorized to take evidence, isn't it? Under the Arbitration Act. However, arbitrators are excluded from the definition for the purpose of this act. Remember that. Arbitrators are legally authorized, but that does not mean that they are included in this definition for this act. Okay? So this is an important provision when it comes to your prelims. Alright, let's go to the next definition. Fact means and includes anything. Fact means and includes. Whenever you see this particular phrase means and includes, fact means and includes, this is what we call a hard definition. That basically means whatever is given right after that is the only thing that will mean as facts. Had it mentioned fact includes, that means it is giving a set of illustrations, right? That fact could be A, B, C, or anything that is not mentioned which is like A, B, or C. But when it says means and includes A, B, C, that means it will only be A, B, or C. Okay? So fact means and includes anything state of things, relation of things, all these must be capable of being perceived by senses. But it does not end over here, because there is another branch to it which says any mental condition of which a person is conscious. Especially when you're studying the Evidence Act or even CRPC or CPC, any procedural provision, try to make a mental map in your copies like this. Instead of writing it down in a sentence format. See, in the exam, you'll obviously not write it in this way. But this is a good way to memorize the concepts. Fact means and includes, which means that a fact can be any of these four things. Now, if you notice over here, there are 2 points mentioned over there, right? Point 1 and point 2. This is category 1. All these 3 over here. And this is category 2. Anything, state of things, or relation of things. What is a thing? A thing is anything that has physical existence. Okay? Now if I ask you, yesterday you probably had a good dinner because today is Sunday, right? Then you went to sleep, you saw a dream. In your dream, you were picking up an object. Is that object a thing? That object is not a thing. Why? Because remember, first of all, a thing means physical existence. Secondly, that thing must be capable of being perceived by the senses. This part is important over here. Capable of being perceived and senses. Right? Which means that the fact, or this first category that we are talking about, falls into the category of external facts. You can say external facts or physical facts. Now, similarly over here, when we are saying a mental condition of which a person is conscious, this is not a thing in the sense that this does not have any physical existence, right? But this has what we would call a non-corporeal existence, right? Or a non-physical existence. It is nothing else but an internal fact. Now let's look at the illustrations that are given there. That there are certain objects arranged in a certain order in a certain place. You are unable to see this part of the board?
Yes, sir.
Please help. Yeah, just give us a moment.
Is that okay now?
Yes, sir. That's it.
Okay, perfect. All right. So the first illustration, that there are certain objects arranged in a certain order in a certain place, is a fact. Okay. Now you're sitting, right? You're sitting in the classroom, you're sitting at your respective places in the home. When you look around, you see that the things around you are arranged in a particular order. They have a particular position and they are arranged in a particular way, right? In the same way, let us say there is an earthquake all of a sudden. Then that arrangement of things changes, right? The initial state of things and that changed state of things, both of these are facts. Okay, very simple to understand. Or plainly speaking, the arrangement of fruits in a fruit store or objects in a departmental store. They are things that are arranged in a particular order. Right? Now remember that over here thing, this concept of thing that we are talking about includes both animate, which means living objects, and inanimate objects. Okay.
What is that?
The example that I gave you of arrangement of fruits in a particular store. In the same way, let us say that the question is whether violence happened in a particular election rally, right? Now, the fact that people were sitting in their particular positions at a particular point of time is a fact. Why? Because it is nothing else but certain objects that are arranged in a certain order. Right? Objects is not being used over here in the sense of just being a dead body or anything that is not human. Right? It could be a human being also. Remember that. In the same way, let us say that violence is being used now because of a very outrageous speech that someone has made. Now when that fight is happening, again, objects are arranged in a different order. So that is also a fact. Clear? Second illustration, that a man heard or saw something is a fact. Okay, this is fairly self-explanatory. Why? Over here it is mentioned anything, any state of things, any relation of things capable of being perceived by the senses. Right? When you're hearing something, whatever you're hearing is being perceived by the sense of hearing. Right? In the same way, when you see something, you're perceiving it by sense of sight. Clear? That a man said certain words is a certain fact. Again, the same reasoning applies. As much as you're hearing something, when a certain man is saying something, it is again subject to perception by other people. Therefore, that saying of certain words is a fact. Now this fourth point over here, the first three illustrations that you're seeing deal with external facts. Fourth and fifth deal with internal facts. Just underline the specific parts of this illustration. That a man holds a certain opinion, please underline opinion, intention, good faith, opinion, intention, good faith, fraudulently, particular word in a particular sense, or conscious of a particular sensation. Now, when a man says certain words, right, you listen to it, that is an external fact. The fact that he said certain words. But with what meaning he said those words is something that you cannot know. He could have used a particular set of words in a particular sense, right? So that is something that only he knows, right? And therefore, it is a mental condition of which the person is conscious.
Yes, sir.
Right? With this example, you can clearly see the difference between an internal and external fact. The other examples that you're seeing over there, a man holds a certain opinion, a certain intention. When we are trying to establish that a particular person is guilty of murder, right? We have to establish mens rea, which is your intention. Now, this question of intention or even motive for that matter, these are things that are only known to the person, right? Indeed, it is true, in many cases we have to look at circumstantial evidence also. But the first point of inquiry is, did the person from within desire a particular set of consequences to follow? Right? The moment we say that intention means the desire to make sure that a particular set of consequences follow. What is desire? Desire is an internal psychological concept. Clear? Alright. Act in good faith, fraudulently, all of these similarly are psychological concepts. And then that a man has a certain reputation. Okay? Now, this might seem a little tricky to understand, right? Because reputation is not something that a person independently has, right? Reputation is something that has to be seen with respect to the people around you, isn't it? But again, at the end of the day, it is an internal judgment, isn't it? Whether a person has a reputation or not is something that is coming from within. It is not something that you can see with your senses in front of you. Therefore, that also is a psychological fact. Okay, so for this, if at all you get any prelims questions, whatever explanation I've given you applies for mains also. But if you get a question for prelims, it will be regarding what is a physical fact or what is a psychological fact. The definition to that lies over here. Psychological, physical or internal, external facts. Okay, now let's come to the two most important definitions in this act. Okay, any doubts, online students?
No, sir.
Okay, I hope this schematic that I've given you is fairly self-explanatory. Once you have this chart in mind, it won't be a problem.
Yes.
And please try to avoid reading Bhattuklal, because that book is a complete waste of time, resources and energy. Why? Because it is given a lot of information and it's it's not, you will not be able to know where to stop reading and where you should not. If at all you want to, isn't it?
Sir, it's so confusing that you said to refer to external, so I ordered external.
And I'm sure you've, yeah, I'm sure you've seen Mainini is a much better book.
Yes, sir.
Right. It's given just the right number of cases, and even those cases have been explained with just the right amount of matter.
Yes, sir. Briefly has been explained.
Exactly. Okay. Now let's talk about relevant. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to relevancy of facts. Now, as you can see over here, this definition is not really doing anything other than just giving an extended meaning of relevance, right? It's not saying what relevancy exactly is. In the way that you are seeing the definition of fact, fact is telling you that it means and includes this. Over here, it is just giving you an indication of how to understand relevancy with respect to this act. Okay? So when you mention this word relevancy, it's over here, it's mentioned, it is relevant to another, which means that we are not talking about one fact in isolation. When we are talking about relevancy of facts, it has to be fact number 1 and fact number 2 are connected in a certain way. Okay? For example, at a crime scene, right? Let us say that a person has been stabbed. Because of this stabbing, two things have happened. First of all, the person who is being stabbed, he is resisting the attack, and because of that, there are marks of struggle on the ground. Right? Number 1. Number 2, because the other person has succeeded in this, there is blood in the crime scene. Okay? Now, when we are talking about relevancy of facts over here, what is it mentioned over here? One fact is said to be relevant to another when one is connected with the other in any of the ways referred to in the provisions of this act. Now let us say the fact number 1 that we are trying to establish over here is the guilt, which we'll slowly know is nothing else but the fact in issue. Okay? Now, this guilt is connected to blood on the crime scene and struggle marks. Okay? Now, if this incident has happened between A and B, and we are trying to prove the guilt of A, and A is saying that I did not intend to do it, right? And it is proven over here that this, from the DNA reports or otherwise, that these struggle marks on the body or found on the ground, they are as a result of this person interacting with another person. Then that indicates the guilt of this person. Right? In a way, we can say that these two facts are connected in a similar way as cause and effect. Right? So, relevancy is nothing else but the connection of two facts in the sense of cause and effect. Alright? It is not always cause and effect, but it is like a connection of cause and effect. Or in other words, when we are talking about, or when we are saying that fact 2 is relevant to fact 1, we are saying that there is a certain degree of probative force. This is the legal phrase that is used. Certain degree of probative force. Essentially, this is indicating some amount of proof. Are you confused anywhere? Now, One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of the Act. In any of the ways referred to in the Act. Now remember, there is this, the mentioning of this particular phrase over here highlights the difference between two concepts: logical relevancy, legal relevancy. One fact may be connected to another fact in the sense of cause and effect, but if it is not declared to be so according to the Act, it is not relevant, right? So when it says connected in any of the ways in the Act, it refers to legal relevancy. Remember that. As an example, I'll tell you, okay? The best example is a confession made in police custody. A person might clearly confess everything, right? But section 25 says what? That a confession made in police custody is not relevant, right?
Yes.
Isn't it? What does that mean? That means that even if it might be logically relevant, because the Act says it is not connected in any way with another fact, by clearly declaring that it is not to be admitted in evidence, that itself shows that it is not legally relevant. Clear? You can cite that as an example. I'm not writing that on the board. Okay. Now, the expression fact in issue, the expression facts in issue, again over here you can see it says means and includes. What does that mean? That means that the definition that is given there is exhaustive. Facts in issue means and includes any fact from which either by itself or in connection with other facts, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability. Okay? Asserted or denied in any proceeding. Asserted or denied in any proceeding necessarily follows. This is the most important part of the definition. It is this part of the definition that shows the difference between a relevant fact and a fact in issue. Because when we are talking about a relevant fact, the fact that blood was found on the crime scene, okay, that is indicating the guilt, okay. But when, let us say, through a thorough DNA examination, it is determined that in fact this person has killed this person, then that becomes the determination of a fact in issue. Because the moment that is determined, it will be held that the person has committed a crime, right? Now, what is the right or liability that we're talking about? The right to freedom that the person has, but the moment it is determined, he has to go to jail. So he is placed under a liability and a disability. Anyway, I'll explain those with reference to the illustrations, but I just want you to look at how all of this works separately, okay? Now look at the illustration. A is accused of the murder of B. At his trial, the following facts may be in issue: that A caused B's death, right? This is directly connected with the existence of liability, okay? That A intended to cause B's death. This is connected with both existence and the extent of the liability. Because even if in a situation we can say that A has caused B's death, but A did not intend to cause B's death, it could be a situation of section 304A, rash and negligent act. Because in rash and negligent act, there is no intention to cause death. Remember that. It is only death which is caused by carelessness. Now, causing death by carelessness is not the same as intending to cause death. So if we first establish that A has caused B's death, that shows the existence of the liability. Then we show that A intended to cause B's death. That will show that yes, the extent of liability is complete. Section 302 applies. Or section 299 applies. 302, 304 applies in terms of punishment. Now, let us say that he did not intend to cause death. That means that it was probably a result of rash and negligent act. In that situation, again, we are determining the extent of the liability. So even that is a fact in issue. Now, that A had caused grave and sudden provocation from B. That deals with both the nature and extent and existence of liability. Right? Because the moment we establish that a person has suffered grave and sudden provocation, murder is reduced to culpable homicide. So the extent of the liability is reduced. Right? That A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its nature. Now over here, existence of liability itself is not there. There is no question of extent, because first of all, question of extent will arise if there is existence of liability. Isn't it? Because the person is of unsound mind, he is not liable at all. Hence, that indicates non-existence and nature of liability. Clear? Now, I'll give you another example which is not there. Let us say that we are talking about a succession suit. Okay? Now, I'll give you the facts over here. Let us say this is a father. This is the mother, this is son 1 and son 2. Okay, now let us say that this person dies. Okay, We are talking about succession to separate property over here. We're not talking about co-partnership. If we are talking about separate property, what is the enactment that you have to deal with? Hindu Succession Act, right? Now, under the Hindu Succession Act, sons, whether they are adopted or blood, both of them are class 1 heirs, right? Of course, the widow over here is a class 1 heir also. But let us say that over here S1 says that S2 has not been validly adopted. Right? So let us say that over here S1 files a suit against S2, saying that, or asking for a declaration that he is entitled to this share and this person is not. What is the fact and issue over here? Go back to the definition. Any fact from which, either by itself or in connection, the existence of any right, liability or disability. Okay? Now, if over here S2 succeeds in proving that he was validly adopted, then that will show the existence of his right to get the property. Okay? In the same way, if S1 establishes that S2 has not been validly adopted, then simultaneously he will show the non-existence of the right of this person to succeed, and also the existence of his and his mother's right to half of the property each. Okay? And thereby also he will show the extent of the right. So, what is the fact and issue in this case? Whether S2 precisely. Yes, please go on.
So the adoption of S2 is the fact issue.
Precisely. The fact and issue is whether S2 is a validly adopted son or not. Okay? Now, as you have already seen this example, you can directly take a look at the explanation to this section. Whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact and issue. Okay? Now, over here when it says under the provisions of the law for the time being in force relating to civil procedure, it is talking about nothing else but Order 14 Rule 1. Order 14 Rule 1 says what? That issue will arise when a material proposition of fact or law is asserted by a party and denied by the other, right? Which thereby leads to an issue of fact. In this example that I gave you, under Order 14 Rule 1, what is the material proposition that is being asserted? It is being asserted that S2 is not the adopted son. What is simultaneously being denied? That he is the adopted son. So this is an issue of fact. So the answer to that issue of fact is what? Whether he is adopted or not. Right? So that itself is a fact and issue. And also remember, over here it's mentioned in any proceeding, which means that this applies to both criminal and civil proceedings. Clear? If anyone asks you the Indian Evidence Act whether it is applicable only to civil proceedings or criminal proceedings, the answer to that question you can find if you just look at section 1 first. Section 1 says it applies to all judicial proceedings in or before any court, which implies both criminal and civil. Secondly, in the definition itself over here it is given.
Yes.
Right? And then the definition of court includes both judges and magistrates. Okay. Yeah.
So that time we told about that arbitrators. Could you please define what is arbitrators?
Okay. Have you heard of the Arbitration Conciliation Act? Okay. Now, let me just wipe this off. Okay, I hope I am being able to teach you guys this in a slightly more interesting way than you might have been taught in law school.
Yes, sir. Yes. Yes, sir.
This is one of the most, it's a little technical and dry, that's the thing. But then nothing beats Article 16 in the Constitution, isn't it? For the ones who have studied that. Okay, anyway, so you are asking arbitration, alright. Now, how is a dispute resolved? Parties will go to a court, there has to be a judge, the judge will follow a particular process which is given in these laws, right? And then the dispute will be settled. But the following of this entire process, whether it is civil procedure, criminal procedure, and coupled with the rules of evidence, it takes a long time, right? Now let us say that the dispute is a contractual dispute. Person A promised that he was going to build a software park for person B for 40 crore rupees, right? And the possession of the land was given to party A, and let's say 5 crores was given as an advance or 10 crores was given as an advance, but party A simply did not go ahead with the construction. Now mind you, the amount of money is 40 crores, right? If this dispute is resolved in a court, it will take a long period of time. Why? Because of procedural formalities, calling of witnesses, production of documents, and all of that will take a long period of time. So in this sort of a situation, let us say that we allow both the parties to appoint one person to decide the case between them. Okay? And we will say that whatever that person gives as the decision between these two people will be respected by the legal system. Okay? And that person, when he is deciding the dispute, he is not bound by any technical rules of procedure like the court is. Don't you think that will be a faster resolution of the dispute? Right? Why? Because that is a private tribunal. In the court, there is listing of multiple cases that happens from day to day. So it's very difficult that one single dispute will be heard in its entirety, right? Multiple days have to be passed before a decision is given. Whereas arbitration proceedings, because they are a private tribunal, it can be conducted from day to day, and within 1 week the entire proceeding, 1 week or a month or 6 months as the maximum time limit is given, it can be completed. Right? So that process that we are talking about is arbitration. Okay? It is something that is happening outside the court, but the ultimate decision will be respected by the court and the broader legal system. Clear? For which reason over here it is mentioned that the Evidence Act does not apply to arbitrators. Right? And court, although it includes all persons legally authorized to take evidence, that definition does not include arbitrators.
And that is not a judicial proceeding.
That is not a judicial proceeding, no. It is what you would call a quasi-judicial proceeding.
And that will be legally valid, sir.
That will be legally valid, yeah. Okay.
Does it apply to the criminal proceedings also?
Arbitration is not possible in criminal proceedings.
Only for the contractual and small bit.
Obviously, I mean, think about it. In terms of public policy, do you think arbitration should be allowed? Right? It has to be one particular court which is established by the state itself. Because when it comes to criminal law, the foundational principle of criminal jurisprudence is that the state is the guardian of the citizen, which basically means that the state has to provide the entire procedure and the platform and the infrastructure for justice dispensation in criminal case. Right? Okay, next definition, document. This is a very short and easy one. You can just underline the important parts. Document means any matter expressed or described. Just underline matter expressed or described. Upon any, underline substance, by means of, and you can underline letters, figures or marks. You don't have the Bare Act? Okay, that's fine. Letters, figures or marks, or by more than one of those means. Intended to be used or which may be used, then underline, for the purpose of recording that matter. Okay? Any matter that is expressed or described on any substance. Okay? Now this expression or description, this or this is done by the means of letters, figures or marks. Okay? And the purpose of using these letters, figures or marks on the substance is to record the matter. Now, although again it's not important for prelims, no one is going to ask you that. Can you tell me the difference between expressing something and describing something? Because in law, when you're studying, yeah.
The express, I think, sir, refer to oral documents and describe documentary, I think, form of, I think.
Not exactly. See, in both expression and description, you are writing something, right? But there is a difference when you are just using a pen and let's say you are writing on the board, on the table, on the wall, anywhere, right? Why am I saying table, board or wall? Because this expression or description has to be done on a substance.
Yes.
Right? I'm quite sure you would have seen the laying down of gas pipelines. Right? Gas pipelines are being laid throughout the city right now. I'm sure you have seen there are certain those small pillar-like structures on which it is mentioned GAIL. Right? Gas pipeline going through. You have seen those structures? Right? What is that? That is a rock.
Yes.
Isn't it? But that rock is a substance, and on that substance something has been engraved. So when you are engraving something, you are describing. That is what description means. But if you are just using paint to write something on it, then that is expression. So that's the difference between expression and description. Remember that. Right? So now the reason why I'm giving you that example of the small stone pillars that you're seeing next to the road is because remember that is also document. Now in our normal sense of using English, we think that document is what? Pen and paper, right? A book that you're reading, a file, all of those are documents. But over here, the meaning of documents is much wider than that, right? And why did I say stone pillars? Because on the stone pillar is a substance. Right? When you are engraving something with the stone, on the stone, that becomes matter which you are either expressing or describing by means of letter, figure or mark. This one is fairly understandable, right? And then the purpose is to record the matter, which means that the matter will stay for a certain period of time. Clear? In the same way, tell me, let us say that there is a dispute regarding a particular archaeological artifact. Okay? Certain cave explorations have been done. An artifact is discovered, right? It has certain drawings and something is mentioned in a particular language which, let us say, Hindus are claiming belongs to our history, Muslims are claiming it belongs to our history. This is the basic dispute in question, right? Now, obviously, a dispute has to be established by evidence, right? Now, the production of this particular artifact that I'm talking about, or let us say it is a stone carving that has been found. That stone carving itself, when it is produced in the court, that itself is a document. Why? Because it is expression or description of matter. Could be cave drawings, doesn't matter. Indus Valley civilization ruins, I'm sure you've seen many of those things, right? And it is on a substance, the substance being the rock. And it is done by letters, figures or marks. Marks over here is the key point, or figures. And it is for the purpose of recording the matter. In the same way, let us say that you have a tape recorded conversation. Is a tape recorded conversation a document? Any answers? Is a tape recorded conversation a document?
Sir, it is not electronic document, I believe.
It is a?
Electronic document.
Very good. It is an electronic document. But I want you to just explain with regard to this definition.
Sir, when the conversation is recorded,
Yes.
it is sent to the forensic department or the call recording department.
Okay.
Verified. Once they verify and submit the document, it becomes electronic document.
I understand. See, that is the procedure for accepting it. But I'm purely asking on a logical basis. Is it a document? Does it satisfy this definition?
No, sir, it is not a document. Because it is by use of letters or.
See, if you just purely look at this definition, what does it say? It is any matter that is being expressed or described on a substance. When we are talking about a tape record, that tape is the substance, right? The voices that you are recording are the matter.
So it's a document.
And it is being expressed or described. Expressed or described could mean embedded also, right? By means of letters, figures or marks. You must have seen when you look at the tapes, there are certain, there is a certain pattern and design on it. That is the letters, figures or marks. And the purpose over here is to record the matter. So it comes under the definition of document, but more specifically electronic document. Okay, now just quickly take a look at the definitions, the illustrations given here. A writing is a document. This doesn't need explanation. Yeah,
Sir, I have one more doubt.
sure.
Sir, it's written that intended to be used or which may be used. Sir, what is the difference between the two things? Intended to be used or may be used?
Intended to be used? Okay. See, that basically means that whatever substance that you are recording on, let's say it's a piece of paper, right? Now that piece of paper is normally something that someone would intend to use to record the matter, right? But a rock is not, isn't it? But that does not mean that you cannot record the matter on the rock. So this basically simply tells you that it doesn't matter what substance you are recording on. It could be something on which you would intend to record, or it also could be something which you may not intend to record, but which potentially can be used for that purpose also.
Okay, sir.
Okay. Now the second illustration is words printed, lithographed or photographed. Photos are documents. Same explanation over here, right? Now lithography is again nothing else but writing on rocks. A map or a plan is a document. An inscription on a metal plate or stone is a document. Your high security registration plates or any number plate even before that. All of these are documents at the end of the day. A caricature is a document. A caricature is, can anyone tell me what a caricature is? Yes, that is a caricature in the present sense of the term, but the time when this was being made, it was a model of a particular thing. If anything is a copied model of another thing, that is a caricature.
So what is caricature?
Copied model.